Hi, I'm Mary Fitzsimmons. I'm your Washington Realtors legal hotline lawyer, and this is another episode in our series discussing substantial changes to the Washington Residential Landlord-Tenant Act. And we are once again fortunate to be joined by Jennifer Hohnstein, lawyer with Williams Kastner in Seattle, specializing in landlord representation under the Washington Residential Landlord-Tenant Act, and particularly with respect to eviction work. And we're also fortunate to be joined by Mary Hull-Drury, the Washington Realtors Government Affairs Director. So today, let's talk about delivery of the notice to increase rent. So in prior episodes, we've discussed the rent cap itself, and we've discussed the fact that notice of a rent increase has to be delivered on a specific statutorily required form. There are a few exceptions of landlords who are not subject to the rental cap. In this episode, Jennifer and Mary, let's focus on delivery of that notice. How does it get delivered? When does it have to be delivered?
So when is easy. At least 90 days before the rent increase goes into effect. And when I say at least 90 days, I want to emphasize that that's the floor, not the ceiling. Some other jurisdictions, Seattle, for example, has 180 days that needs to be delivered before. So some localities have increased the amount of days, but as a bare minimum, it's 90 days.
Everywhere in the state, the minimum is 90 days. You're in Colville, Washington, you're in Bingen, Washington, you're going to have a minimum of 90 days. And then there are some local jurisdictions around the state. And it's not even fair to say just primarily on the I-5 corridor. They could be anywhere.
Yes.
Right. Anywhere around the state, your local jurisdiction may require longer than 90 days notice. Nobody can require less than 90 days. Nobody in Washington state can require less than 90 days. But some local jurisdictions may require delivery of the notice to increase rent more than 90 days. And how would they know that? Just they would have to talk to a local lawyer? How would they learn a local jurisdiction's requirement?
Going to counsel within the locality. So you need to make sure that whoever you're going to and talking to understands the rules that apply to whatever city you are located in.
City or county, right?
Well, yes. City and county.
Right.
Yes.
I mean, because Seattle could be different from King County, for example. If you're in the city of Seattle, it could be different than if you're in King County, outside of the city of Seattle.
There could be some differences with unincorporated King County. I suppose, yes. Wherever they specialize in knowing what rules apply to your address.
And I'm sorry, I'm not trying to make that more complicated than it has to be, but you really do need to work with counsel who understand the local law in your area. Because if you live in Tacoma and you comply with the federal way requirements, you might not have delivered adequate notice to increase your rent, and all of a sudden your rent isn't increased. And there can be a difference just even in zip codes that are as close together as Tacoma and Federal Way. There could be a substantial difference in the amount of notice that's required.
Oh, certainly. And a really good example as well is Puyallup versus Tacoma. I mean, two neighboring cities in Pierce County, and they definitely have such a different focus on rules. And so wherever you're located, make sure that it's somebody who understands the nuances in your area.
Okay. So 90 days notice is the basement, not the ceiling.
Yes.
And then we also wanted to talk about the requirement for making delivery, not the deadline, but how do you make delivery of this notice to increase rent?
So currently, they have incorporated sections from the Unlawful Detainer Act and using the same notice requirements. And it goes as follows. You first have to have an attempt of hand delivery. Here is your notice.
Thank you.
You're welcome. So you first have to try for hand delivery. If that doesn't work, you can hand it to somebody of suitable age within the dwelling. And of course, suitable age, what does that mean? But somebody within suitable age within the dwelling. But if you give it to somebody within suitable age, you have to then mail it to the person as well. As well, let's say that you knock on the door, no one answers. The tenant's not there, there's no one of suitable age. You then post on the door, which means taping a copy, get out that blue painter's tape, taping a copy to that door, and then mailing it to the tenant. And I also, though, want to highlight that there's going to be different mailing requirements. From now through July 26th, you can, so long as it's within the same county, just go and put a stamp on it and put it in the mail. You're good. But starting July 27th, a new law is going to go in effect, which means you need to deliver it through certified mail. So if you hand it to somebody of suitable age, or if it's posted to the door, you need to make sure you then go and have it certified, delivered through certified mail as well.
So let's unpack this a little bit. Anybody who has given the 3-day pay or vacate, they might be familiar with this knocking on the door process. But if somebody's never done that before, this is brand new for them. So when you talk about making delivery to somebody of suitable age, what you're talking about is landlord or your manager or somebody on your behalf is knocking on the door of this residence,
yes.
right? And it doesn't matter, landlord, you might live in Spokane and your property might be in Clark County. Somebody has to knock on the door. You cannot raise rent by simply emailing a tenant and saying your rent is increased in 90 days, even if you attach the right notice. It's not effective to increase rent. Correct?
That's correct.
You have to now make physical delivery of the rent increase notice, which means somebody has to knock on that door. And if the tenant themselves answers, you can hand it to them, correct?
Yes.
And then you've made delivery and you don't have to do anything else. Except here's what you have to do. You have to create a journal documenting what you delivered, when you delivered it, and I don't mean just the day, I mean the time and the day, to whom you delivered it. If you don't recognize this person as the tenant, then you describe what they looked like, and that you asked them, "Are you Mr. Smith?" And they said, "Yes, I'm Mr. Smith." Is that fair?
It is, as well as what your counsel will most likely be asking is for you to sign a declaration saying that under penalty of perjury, you did serve the notice and describe the method in which you served it.
Okay. So if you're delivering it to the tenant themselves, that we've just described that. If the person who opens the door, you're renting to Mr. Smith and somebody who looks like maybe they're a 14-year-old-ish girl answers the door, you should say, "Is Mr. Smith here?" No, he's not. Then what would you suggest if we're delivering to somebody who looks to be a 14-ish year old girl? Is that a person of suitable age to be able to hand them the notice?
It depends. There's different interpretations of suitable age. My recommendation is if they look to be under 18, don't do it. If you have a weird, funny feeling about, should I be delivering to this person? Don't do it. Because at the point where you're delivering to somebody of suitable age, you still have to mail. And so you don't want to risk somebody saying that that person wasn't suitable age, or that person was younger than they appeared, or there were some other issues. You can always tape it to the door with your blue painter's tape and then mail it.
So if we're questioning whether they're somebody of suitable age, you would just say, when they say, "No, Mr. Smith's not here," you would say, "Okay, thank you."
Yeah.
Allow the door to be closed. And then you would tape onto the front of the door before you walk away?
Yes.
Okay. And then you go back to your office, and between now and July 26th, you do what?
Between now and July 26th, you go and you put a stamp and you put it through the mail.
So you take a copy of that exact same notice,
Yes.
put it in an envelope addressed to the tenant at their residential address,
Yes.
regular stamp, blue USPS mailbox,
Yes.
off it goes.
Yes. But the day that July 27th hits, suddenly it's now certified mail. So you no longer can just put that stamp on it. You actually have to have that higher certification. That way, I believe that the intention was so that there's more proof that the tenants get it. Personally, I think that a lot of people don't sign for certified mail, but either way, you have to try.
Which means, brokers, you are going to keep record not only of your efforts to make personal service on this person by knocking on their door and describing again the conversation you have, even if the summary of your visit to the property is that you taped it to the front door. You are also then, after July 27th and thereafter, you are going to retain in your firm's transaction folder proof of your efforts to make the certified mailing. So your receipt showing that you mailed it certified, even if you don't ever receive back the return receipt signed by the recipient, you're going to retain proof of that for your firm's transaction folder.
Yes, you will never get in trouble for over-documenting. You could get in trouble if you under-document. So I know that some people actually take photos with their cell phone when they post on their door, just for one extra layer of verification to be able to say, look, I did actually post it here.
Mary, we didn't make you say anything during this video. Do you have anything to add?
Well, I had a question. We kind of hit on it just a little bit, but let's say, for instance, there's nobody home, no tenant, and no person of suitable age, and it's after July 27th. So then you have to send it certified mail.
You have to post on the door.
Post on the door and send it certified mail.
Yes.
But nobody signs for it.
Okay.
What happens then?
You smile because you've complied with your legislative duties.
Perfect. All right.
And as your lawyer is going to have you sign a declaration stating that you did exactly that. You posted it on the door and then you mailed it certified mail.
And in that situation, you also might want to talk to your lawyer about whether or not to go through abandonment procedures. Because if people aren't actually there, it might mean that they have left and not told you. So in that case, your attorney will be able to guide you by step how to actually determine if the tenant has abandoned the property without you knowing it.
And when you say that, you're thinking about the delivery of 3-day pay or vacates. We're just talking about rental increases. So if somebody's paying their rent, we're not worried about abandonment, right?
If people are paying their rent, they're good tenants, of course we don't worry about abandonment. It's whenever there is a lapse in payments, whenever there's issues that are arising, at that point, if you have reason to believe that the person has vacated the property and you're not able to reach them, at the point where you are having concerns and you're not receiving that rent payment, you need to start going through some definite procedures for whether or not they have abandoned the property. The caveat is, it's very, very important to get it right, because if you retake a property and you regain possession, but it's too soon, there are some extremely strong penalties that will come down. So you never want to get this wrong, and you never want to prematurely retake possession of the property.
And so let me conclude this video the same as the others, right?
Yes.
You're going to call your lawyer or your landlord. If you're a property manager representing a landlord, make sure you're dealing with your landlord's lawyer about how they want to proceed with any of those actions. And if you have any questions about how to make delivery, this is to me one of the more mind-boggling aspects of all of this, that you have to actually make a physical appearance at somebody's door in order to increase the rent. You're welcome to ask me questions about it, but the answer is unfortunately not going to change. That is the requirement. You can no longer just mail or email a notice of rent increase. So if you have questions on this topic or any other, ask me a question by visiting warealtor.org and following the links to the legal hotline. Thank you for being a Washington Realtors member.